Welcome back. I have a question for you today, and I want you to actually sit with it for a second. If someone started using a brand name tomorrow, a competitor, for example, a company in an adjacent industry, some random business on the other side of the country, and you had to go to court to stop them, would you win? Now, most founders assume the answer is yes, especially if they've been using their name for years and they have customers that know it by name. They have a website, social media profiles, maybe even some press coverage. Of course they would win, right? That's what all of us assume. But the legal reality is more complicated than most people think. And I want to walk you through the 5 factors that actually determine whether you can successfully defend your brand in court. Let's talk about factor 1. Do you have federal trademark registration? This is the single most important factor. Common law trademark rights do exist, meaning that you can have some rights in a name just by using it in commerce, meaning offering goods or services for sale across state lines. But common law rights are limited to the geographic area where you actually do business. If you sell products in Texas and someone starts using your brand in New York, your common law rights probably do not reach them. And a federal registration will change that. That's why you need it. It gives you nationwide priority from the date that you file your application. It creates a legal presumption that you own the mark, and it gives you access to federal court with enhanced remedies, which means generally the remedies are either going to be your lost profits or the defendant's profits being disgorged. Like they can't keep the profits they earned off of your mark, right? It's called disgorgement of profits. Whichever measure of damages is used in that case, the court will multiply it by 3. It's called treble damages. It's also called enhanced damages or enhanced remedies. You can go to federal court, and with enhanced remedies, including these statutory damages, you can also recover attorney's fees if you're successful and the costs of bringing the case. You've got very powerful remedies available to you if you have a federally registered trademark. Now, if your competitor has federal registration and you do not, they have a massive legal advantage, even if you started using the name first. Now, I want to say there's a solution to this, and I deal with this all the time with clients who were using the name first, and then a competitor started using it and got registration first. You can petition to cancel their registration based on your prior use, your senior rights in the mark. There is a remedy there for you even if you don't have federal registration, but it's more expensive and complicated than just getting registration as soon as possible to use your marks. That's the first question. Do you have federal registration? Factor 2, how strong is your mark on what is called the distinctiveness spectrum? And I've talked about this in another video, but fanciful and arbitrary, if you think of it as a spectrum, you've got the strongest marks are called fanciful marks or arbitrary marks. Those 2 types of marks are the easiest to defend. On the other end of the spectrum are descriptive marks, and descriptive marks are the weakest marks. If your brand name literally describes what your product does, defending it in court is going to be an uphill battle because the other side is going to argue that they have an equal right to use descriptive language about their own products. Now, that is true, but we're talking about using it as a source identifier, right? That's what a trademark is. It's a little bit more of a niche use of that descriptive language, but generally descriptive marks are not registrable. Now, I don't know if you guys remember the UGG brand boots, but the UGG case, there's a trademark case from October 2025. It's a perfect cautionary tale because a federal judge in the Northern District of California ruled that the UGG Classic Mini, Ultra Mini boot and the Tasman slipper designs were legally generic, meaning they had become the standard look for that type of footwear and could not be owned exclusively. Even as a brand as iconic as UGG can lose the ability to enforce its design rights if those designs become too commonplace. In particular, shoe companies are more and more getting trademarks in the look of their shoes, not just their logos. Air Jordans also have some trademarks. Kate Spade has some trademarks in her bags, the shape of her bags. But you can lose those if it becomes too commonplace. So you have to enforce your rights to keep others from using it once you have registration. Factor 3 is, can you prove your use, like your actual use of the mark in commerce? Courts are going to want documentation. So you need to have proof of when you first started using the mark and in what geographic areas and on what goods or services. Do you have dated invoices? Do you have advertising materials, screenshots of your website over time, social media posts with timestamps? Do you have pictures of your products with hang tags or packaging with the mark on it that are dated photographs so you can prove the timing. If you cannot prove when and how you started using the mark, your priority claim is going to be weak. I tell every client you need to start documenting your brand use from day one, save everything, screenshots, receipts, packaging, promotional materials, keep a file, keep it current, make sure every document or image saved is dated. And this evidence was really going to help you. It's going to become critical if you ever need to establish priority in a dispute. And sometimes these disputes happen years later. You don't want to assume if you haven't had a dispute in the first couple of years, it doesn't matter anymore. That's not necessarily true. Okay, let's go to factor 4. Have you been policing your mark? Let's say you have registration. Trademark rights come with an actual legal responsibility to enforce them. If you've known about infringers and you've done nothing about it, a court may find that you have what's called acquiesced to their use of your mark. And there's a legal doctrine called laches, which penalizes unreasonable delay in enforcing your rights. Now, what's considered unreasonable is up for definition, and that's what a court would likely decide. But delay can significantly weaken your case or even bar your claims entirely. Starbucks is one of the most aggressive trademark enforcers in the country, and they do it for a reason. A lot of people get angry at these brands for going after infringers that tend to be small businesses, but they have to do it. They have a legal obligation to do it because they have registrations. And under the Lanham Act, which is the Trademark Act in the US, you have to do this in order to maintain your rights. Just by way of example, Starbucks sued a 10-foot wide coffee shop in Astoria, Oregon called Sam Bucks, run by a woman named Samantha Buck, who argued it was just her name. But the court sided with Starbucks and awarded $300,000 in damages, which seems extreme. But if Starbucks did not enforce against small infringers, they could lose the ability to enforce their rights against larger ones. And the legal system requires consistency. It's not looking at the size of the infringer. Factor 5, is there a likelihood of confusion? This is the big question. It's the core question in any trademark dispute. Would a reasonable consumer be confused about the source of goods or services because of the similarity of the marks? And courts look at multiple factors, including the similarities of the marks themselves. Are they identical phrases or words? Are the logos very, very similar? They're also going to look at the similarity of the goods or services. They're going to look at the channels of trade. Are they selling in the same channels of trade? They're going to look at the sophistication of the target buyers. What kind of thought and research and care go into the buying decisions for that type of product or service? And then they're also going to look for evidence of actual confusion. Where consumers are actually confused, that is powerful evidence of confusion that will help you establish infringement. There's a case called Chanel versus What Goes Around Comes Around. And that in that case, a luxury vintage reseller in New York was using Chanel logos and imagery so prominently in its marketing that consumers could reasonably have believed that there was an official affiliation between the two companies. Because of that, a jury awarded Chanel $4 million in damages in February of 2024. But in the Adidas v. Thom Browne case in 2023, a jury found no likelihood of confusion because Adidas's 3 stripes, that they put on their shoes and other products, and Thom Browne's 4 bars, as they call them, their design, because the products, the price points, the customer base were so different, they found no likelihood of confusion. Context and the specific facts matter enormously in these cases. Here is your self-assessment. You need to ask yourself these 5 questions, honestly, the ones I just went through. 1, do you have federal registration? 2, is your mark strong enough on the distinctiveness spectrum, or is it descriptive? 3, do you have dated documentation of your use going back to the beginning? 4, have you been actively monitoring and enforcing your mark when you find infringers? And 5, if someone used a similar name in your industry, would customers actually be confused about the source? If you answered no to one of these, you have work to do. And the time to do that work is now, not when you're already in a dispute and scrambling to build a case that you should have been preparing all along. This is what I do for clients every single day. Every business is different. Specifics matter. If anything in today's episode hit close to home, as you worried, you realize that maybe you got some work to do to protect your brand, I want you to know that I offer free consultations where we can sit down together, look at your specific situation, and figure out exactly where you stand and what your next steps should be. It's just a phone call. I just try to keep it as simple as possible. There's no pressure, no hard sell, no obligation. It's just a real conversation between us about your business and what you need to do to protect it and to protect your brand. And you can book that at my website, leveragelegalgroup.com. Very easy to do on the contact page. I'll look forward to having that conversation with you, and I will see you in the next video.